Assalamualaikum warahmatullahi wabarakatuh. My name is Aisyah binti HUSSIN, and I will be presenting on behalf of the appellants on the first issue, which is whether the appellant are entitled and have the right either in law or in equity to compel the respondent to compensate them fairly and fulfill their promise, since the appellants have occupied the state land area before the establishments of the PKENK. According to Section 66, Clause 1 of the National Land Code, it states that the temporary occupation license toll for state land can be issued or renewed by land administrator on behalf of the state authority. Thus, if there any issue pertaining the temporary occupation license granted for the state land, the land administrator has authority over it. And according to Section 44 and 45 of the National Land Code, the holder has right open the processory right, open the granting of the toll by the land administrations. And in the case of Buhari Taib and Pengarah Tanah Galian Selangor, the Supreme Court held that the occupier's license have rights in equity compared to the squatters. And in this case, the appellants are the lawful occupants of the aforementioned land as the toll holders. Their on-time payments of the toll until 2015 demonstrate that they gained permissions from the state government to continue enjoying lands, and their right as toll holder are incontestable. In addition, the Kelantan state government has already recognized the presence of the appellants' lands, as there were no any acts by the state bans or requests for the appellants to remove the lands if they were prohibited from using the state land. And in addition, numbers of governmental authorities, members and politicians came to their lands and give their aid financially. The appellants believe that they will be allowed to continue on the land is based on their enjoyment right and their ability to inhabit the lands peacefully and without interference from any other person. Thus, the appellants in this case are not squatters but occupied with license, since they are toll holders. Thus, they should acquire legal rights in law and equity as a legal license with legal occupations. Therefore, the appellants should be protected under the doctrines of equitable of estoppel. And according to Section 3, Clause 1 of the Civil Law Act 1956, is allow the applications of common law of England and rules of equity in Malaysia, and this shall include the doctrines of equitable estoppel. In the case of Ramsden and Dyson, 1866, it was determined that in order to rely on property estoppel, firstly, the landlord must have given the claimant some encouragement. Second, the claimant must have a reasonable belief that he will obtain a sufficient interest in the property, and the claimant must have incurred expenses or add to his detriment. In the case of Q. Ahbah and Hong Ah Mei, 1971, the Singapore High Court held that the $15,000 is a reasonable compensation to the defendant to deliver vacant possession of the premise to the plaintiff. And by considering, in this case, the appellant's prompt payments of the toll, and the respondent denied the appellant's rights to be adequately paid under the equity, and based on the offered compensation, equitable estoppel occur against the respondent, as they are not entitled to possession until the appellant's equity has been satisfied. And the appellant has spent a substantial amount of money to develop the land, which earlier was a jungle until recently. And the compensation offered by the respondent, which range from 500 ringgit to 1,000 ringgit, is insufficient to cover all the expenses and losses incurred by the appellants. In addition, respondents had breached their agreements with appellants to build and sell each affected family a new low-cost home. The broken promise by the respondent caused the entire family lost their home, and as a result, the respondent was barred by equitable estoppel from asserting their strict legal right, as they were binding by the promise. As the conclusions, the appellants are entitled and have the rights either in law or in equity to compel the respondent to compensate them fairly and fulfill their promise, since the appellants have occupied the said lands area before the establishments of the PKENK, as according to Section 66, Clause 1, Section 44 and 45 of National Land Code, and Section 3, Clause 1 of the Civil Law Act 1956. That's all from me. Thank you.
Next, for the second issue on whether the respondent can force out the appellants out since they refuse to vacate the land. So under Section 44, Clause 1, Paragraph A of National Land Code, temporary occupation license holders has the right, including exclusive use and enjoyment of the land. And we can see the example in the case of Muhammad Said and Fatima, which is, in this case, the High Court stated that the licensee has the right to immediate and exclusive possession to the land, and the right to the exclusive possession of the land were given under temporary occupation license, and the right will only end when the license already passed the designated date and it become invalid. In the case of Leka Bibi and Maidin, the court in this case held that the temporary occupation license holder is subjected to the action for ejectment in tort, we like at the instance for temporary occupation license holder, and thus a temporary occupation license holder who is in the possession of the state land can sue any trespasser. And in this situation, the appellant clearly have the right of the land, as the temporary occupation license was still valid when the respondent asked them to vacate the land in 2015 before the expiration date of the license, and hence the respondent cannot force the appellant out, as they have exclusive possessory right to the said land, and the appellant also can sue the respondent if they enter the land without the consent of the appellant, and they can sue them on trespass. Also, in Section 3, Clause 1 of the Civil Law Act 1956, the Common Law of England and rules of equity can be applied in Malaysia, in which it requires service of valid notice with a reasonable time to vacate. And the Supreme Court, in the case of Chun Lin Hao against N. Fong Lui, they stated that a reasonable notice of revocation is entitled to those whose license is revocable. So in this situation, the appellant should have given a notice also with the reasonable time by the respondent to vacate the land. And in the case of Embang and Mujur Zaman, the High Court had that the appeal would be rendered nugatory because the defendant might lose the land even before the disposal of their appeal, before the final judgment were made. So in this situation, the respondent forced the appellant to vacate from the land area, and it will be rendered nugatory because the loss of the land will be irrecoverable when the appellants leave their houses even before the hearing end. Also, in the case of Uniban and Malaysia Building Society, the Court of Appeal stated that stay of execution will not be granted if a piece of land is only a mere commercial property without any sentimental value attached to it. However, we can see in this situation, the land surely have the sentimental values to the appellant, as they have been there since 1665 to 1988 with many layers of their generation of their family members. So the stay of execution is applicable for the appellants.
My name is NURLEEN binti Muhammad ZUKI, the Senior Counsel for the Respondent. There will be two issues under this case, and I will be presenting on the first issue, and my Junior Counsel, Ms. IFFAH, will be presenting on the second issue. The issue is whether the appellant are not entitled and do not have the right in law and also equity to compel a respondent to compensate them and also fulfill promises even they occupied the said land area before the establishment of PKE&K. For this, we would refer to the Section 48 of the NLC, where it mentioned that no one is entitled to the state land by possession, unlawful occupation, or occupation under any license, no matter how long. Furthermore, Section 425, where it is stated any unlawful occupation is categorized as an offence, and also Section 341, where it is expressed the adverse possession of land shall not preclude any proprietor or any person or body subject to an interest. Lastly, to Section 47, where state authority shall not be payable to damages with respect to any building when it becomes a property. Here we would like to refer to the case of Datuk Bandar and Tan Po. In this case, although the respondent are toll holders, the defendant still remain as squatters, and also in the case of Siddiq and the government of Perak, the court held that no doubt that these squatters are not entitled to the right in law based on the NLC, as they occupied the land illegally. If we would relate this to the current case, we could see that the respondent, based on PKE&K, had alienated as the new registered landowners, and this had led them to have an indefeasible title. Furthermore, in the case of Saleh and Percon Corporate, where the judge presented that squatters who occupied the huts are contradicted under Regulation 18 of the Essential Regulation Act 1969. In the current case, the appellant are not qualified to the right in equity since they occupied the land contradicting to the NLC and also the regulation and other provision mentioned before. Lastly, the case of Uda Sentosa and Jonathan, where the court ordered that each defendant shall pay the sum of 400 ringgit to the plaintiff. And in this case, it is to note that the defendant are not entitled to any compensation legally since they do not have the cause of action against the plaintiff. Hence, in the current case, the respondent, which is the registered landowners, they are not liable to pay the compensation and also fulfill promises to the appellant, as the appellant themselves had come with an unclean hand. And we could see that the respondent was to offer compensation to the appellant, which is 500 to 1,000 ringgit, but the appellant themselves was dissatisfied with the amount. Therefore, the appellant themselves should not be dissatisfied with the amount, as they themselves had no right in law and also equity to do so.
Assalamualaikum warahmatullahi wabarakatuh. My name is IFFAH binti KAMARULZAMAN, and I will be presenting on behalf of the respondent under issue 2, which is whether the respondent have the right to enter into the land and evict the appellants by using reasonable force, since the appellants refuse to vacate the land. So by virtue to section 42 of the NLC, where the state authority may dispose state land by alienation, and section 92 section 1 of the NLC, where the alienation of state land under final title shall confer indivisible title as provided in part 20. By referring to the case of Raja Mani Anak Perempuan Meyapa Chettiar and urban development, the court held that the landowners obtain indivisibility of title when the title is registered. So by applying to the current issue, the respondent in this case had became the registered landowners of the land after the state authority alienated the land to them. So when the land is registered, means that the person who holds the title is deemed to have indivisible ownership. Next, by virtue to section 44 of the NLC, where the landowners are entitled to the enjoyment of their land, and rule 6 of the ECSR, where the owner of the private land shall demolish the squatter hut on his land within such period as the local authority may in the notice specify. So by referring to the case of Vera Singham Anak Lelaki Subramaniam and others, and the Datuk Bandar Kuala Lumpur, in this case the court repeat the definition of squatter hut, which includes any house which has been erected or is in the course of erection without approval by a local authority, or a license issued by a local authority has been cancelled or has expired. So by applying to the current issue, the respondent have the right over the land alienated to them by the state authority for the public purposes. However, the right was denied by the appellants when they refused to vacate the land. Besides, the houses built by appellants illegally on the state land before the application of toll had fall under the definition of a squatter hut. Thus, the respondent, as the registered proprietor, have the right to use force to evict the appellants and demolish the squatter hut, which is the house erected by them unlawfully. So in conclusion, the respondent in this case are entitled to exercise reasonable and necessary force in evicting the appellants from the land by virtue to section 42 of NLC, section 92 subsection 1 and section 44 of NLC, and also rule 6 of the ECSR.